Okay, we're ready to go. People versus Brittany Lobeck, case number 234869.
Ready, Your Honor. Speaker hearing with the idea from Mr. Lobeck.
Brian Ziegler, yeah.
The record should reflect Ms. Lobeck's present here in court today. Mr. Seeger, can you tell me where we're at with this case?
Your Honor, it's my understanding that Ms. Lobeck is going to tender a plea to an added count 2 of possession of analogs in exchange count 1 and enhancements.
That's correct, Your Honor.
Okay, and is that a 2-year?
Correct, and $2,000 fine, Your Honor.
Okay, do you have the PAC code for that, Mr. Ziegler?
333.7403 2B as in boy -A.
Okay, and Mr. Seeger, we're going to take the plea to the factual basis as charged.
Yes, sir.
Okay. Ms. Lobeck, have you had a chance to talk to Mr. Seeger about this plea agreement?
Yes, Your Honor.
And is that how you want to proceed today?
Yes,
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do, Your Honor.
Okay, you can lower your hand. Ms. Lobeck, are you currently on any probation or parole?
I'm on a bond.
Okay, but no other kind of supervision?
No,
Okay. And you understand, as I indicated, that the maximum penalty that you could face for this charge of possession of analogs is up to 2 years.
yes,
With that penalty in mind, what is your plea to that charge today?
I plead guilty, Your Honor.
Okay, right now you have certain rights. I'm going to go through those with you.
Okay,
You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all of those rights.
I do, Your Honor.
And can you tell me what's going to happen to those rights by you pleading guilty here today?
I don't have those rights.
That's correct. You're going to be giving those up and waiving them. Has anybody threatened you with anything to get you to enter this plea?
No.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty to this charge because you are guilty?
yes,
The information I have indicates this happened on January 27th of last year, 2023, so about a year ago. Is that the correct date?
yes,
On that date, were you present here in Kalkaska County?
yes,
And while you were here in Kalkaska County, did you have possession of some oxycodone?
yes, Your Honor.
Okay. Did you have any legal right to have that at that
No, I
time?
did not.
And did you know that that's what that substance was?
Yes, Your Honor.
Mr. Seeger, are you satisfied with the factual basis?
Yes, sir.
Mr. Ziegler?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you. Ms. Lobeck, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that it is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that prior to that, you stay in touch with Mr. Seeger
Okay,
so that you're prepared to go forward on that day. Before you leave today, you're going to meet with Mr. Barrett. He's going to set up a date and time for you to do a pre-sentence interview, okay?
okay,
Mr. Ziegler, anything further on this file?
No, Your Honor.
Yes, sir.
And this is Mr. Barrett. We're going to meet with him in the back of the court.
thank you, Your Honor.
Thank you. People versus Ryan Cross, case number 234875.
Ready, Your Honor. Thomas Seeger appearing with and on behalf of Mr. Cross.
Brian Ziegler, yeah. People, Your Honor.
Record should reflect Mr. Cross is present here in the courtroom today. And Seeger, where are things on this file? Please?
Your Honor, there have been plea negotiations. However, at this time, Mr. Cross has asked me to look into a few other things. So if the court gave us another date, hopefully we will be able to resolve it at the next court date.
Mr. Ziegler?
Your Honor, I would have no objection to adjournment.
All right, looks like this is Mr. Cross's first appearance before the circuit court. Was just found over less than a month ago. Given the status of the case, I don't have an objection to that, as well as the seriousness of the charge here. So the court will set this for a plea hearing status conference in about 30 days. Is that gonna be enough time, Mr. Seeger, for you to investigate?
Your Honor, if you gave us 45 days, I think that would probably be a little bit more helpful, but
Okay.
Your Honor, you don't have the half motion day anymore, so if you give us
Oh, that's right.
60 days, that would.
Any objection to that, Mr. Ziegler?
No, Your Honor.
So since the court's allowing that much time, I will make that the plea cutoff. So Mr. Cross, the next time we're gonna be back in court will be in about 2 months. Between now and then, you need to make sure that you stay in touch with Mr. Seeger. On that day, that next court date, there is, if you do want to accept the plea, then we'll take that plea on that date. If you decide that you don't want to accept a plea on that date, then we'll set it for trial and the court won't accept any pleas after that date. So that's going to be really important for you to be ready with a decision, okay?
Yes, sir.
Mr. Seeger, anything further that we need to address here today?
No, no.
Mr. Ziegler?
No, Your Honor.
Mr. Cross, do you have any questions about how we're going to go forward?
No, sir.
Okay. Thank you, that's all for today.
Your Honor, can I just look in the feature in there real quick, and see if anything else is.
Yes.
My 9:15 is not here, but Ms. Keeley is here.
You ready to go forward on that, or did you need some time?
I'm all set, Your Honor.
Ms. Keeley, if you want to come forward. We're on the record in People versus Jennifer Keeley, case number 234851. The record should reflect Ms. Keeley present here in the courtroom today. This is the date and time for sentencing. If I could have counsel put their appearances on.
Brian Ziegler, yes, Your Honor.
Thomas Seeger agreeing with an idea, Ms. Keeley.
Ms. Keeley, have you had a chance to go through the pre-sentence report and?
Yes.
And Mr. Seeger, are there any additions, deletions, or corrections?
No, no,
Are there any challenges to the scoring of the guideline?
no, sir.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Yes, Your Honor, and I hope the court will bear with me a little bit. I'm just getting over a bit of COVID.
Sure.
Your Honor, this is a case where Ms. Keeley and her co-defendant, Solis, were found to be manufacturing some cocaine. They were essentially just cooking the cocaine into a crack format. Her co-defendant got 7411 on this case. She was not eligible, as Ms. Keeley was not eligible for 7411. So she took a plea to possession of narcotics. The guidelines are 0 to 9 in this case. The report indicate that she would be a good candidate for supervision. I tend to agree with that. I think the only question for the court today is whether any jail up front is appropriate. I would support giving Ms. Keeley the benefit of the doubt, placing her on probation, holding some jail time in advance over her head, give her an opportunity to successfully complete felony probation. This would be her first felony probation. And if she decides that she can't do that, then the jail time is ready and waiting for her. If she can, then that's to everyone's benefit.
Thank you, Mr. Seeger.
Likewise, Your Honor, I would just ask the court to give her an opportunity to be placed on probation with some kind of incarceration held over her head, which is obviously not good. I think for her, in as much as if she's compliant with the conditions of the probation, she'll never have to serve any of it, or in the alternative, if she violates the tenets of her probation, she'll clearly have to serve the time that's all over her head. She does have a good work history. She does not have an extensive criminal history, in as much as she has in prior felonies in her history. She would have been afforded 7411, but for a prior conviction for possession of marijuana. She has always been good at communicating with me. She has expressed her want to successfully complete her probation. It's unfortunate that she has a prior misdemeanor conviction for possession of marijuana. Otherwise, she presumably would have been availed to 7411. And in as much as I understand, just through reading the report, that the probation department someone had characterized the plea agreement as generous. I don't disagree that it's been lowered to a lesser amount, Your Honor, but I would note, much the same as Mr. Ziegler indicated, that when I think of, say this, but when I think of delivery manufacturer, I think of something greater than somebody reducing it to a different form. And if she was selling it, I think that would be different in terms of manufacturing. But this was a situation where she was just changing its chemistry in such a way that she could use it in a different form, which I guess by analogy would be similar to extracting certain portions of the marijuana plant to make wax or something else. But be that as it may, Your Honor, she acknowledges fault. She would ask the court to consider placing her on probation. I don't have any reason to believe that she won't be successful to get an opportunity.
All right, thank you. Ms. Healy, anything that you wanted to say? I did read through the report. I'm familiar with what happened in this case. There's also a lot of information in that report about yourself and your background and so forth. Looking at the situation as a whole, I do think that probation is appropriate. You've been on probation a number of times on misdemeanors. I think all the indications were that you were successful on your probation in the past. So clearly you're able, when you're under the orders of the court, to follow through, comply, and do the things you're supposed to do. But you are starting to amass a bit of a record now. You've got 8 misdemeanors, this is your first felony. So, you know, sooner or later, you're going to run out of chances on probation. This will be your 7th term, although your first felony probation, but you've been on probation a number of times in the past, and sooner or later, you know, you need to use that probation not just as a way to get through the 6 months or 12 months or 18 months or whatever the probation is, but you need to use that and the resources that you can get through that to work on the issues that keep bringing you before the court. Because the goal is not for you to just successfully get through probation. The goal is for you to not come back. And the more that you come back and the more your record builds up, and the more times you're on probation, successful or not, sooner or later, whatever judge it is looking at that's going to say, well, we've tried probation this many times. She's still coming back. Now it's time for something different. And once you've had jail and probation, the only other option is prison. I don't think that's something that I want to do. So I hope that you use this term of probation more as a rehabilitative thing and use the resources that you can get through probation to help you. I think you will be successful. Again, you've been successful in the past, but I think holding some jail time over your head will also help hopefully provide that motivation. So the court is going to follow the recommendation to the extent that it is going to place you on probation for a period of 12 months. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. The court is going to impose 6 months of jail time with credit for 2 days served. The court's going to hold the balance of that time in advance. So if you do successfully complete your probation, you won't have to ever serve that jail time. However, if you violate your probation, then the court can impose any or all of that time up front without any kind of hearing or anything, because I'm holding that in advance. The court is also going to order that you pay a crime victims assessment of $130, supervision fee while you're on probation of $30 per month, court costs of $325, attorney fees of $350, the DNA testing fees of $68.
Your Honor, I think it's $60. I think that might supposed to be the statement.
Oh, okay. That's, yeah, thank you for that.
Yeah, no
$60 state cost and a DNA testing, $68 state costs and a DNA testing fee of $60. You do have the ability to appeal the sentence and.
Yep.
Mr. Seeger, if you could provide Ms. Keely with the papers. These papers, Ms. Keely, are going to explain to you what your appellate rights are, as well as how to request a lawyer to help you with that appeal. And Mr. Seeger is just going to ask you to initial that you've received those.
Your for the record, returning a copy of the appellate rights.
So just meet with Mr. Farrell. Good luck going forward.
Miss Barney is here as well.
Ms. Barney, if you want to come forward, please. We're on the record in People versus Karen Barney, case number 2348864. The record should reflect Ms. Barney's present here in the courtroom today.
Thomas Seeger appearing with on behalf of Miss Barney.
All right, so Ms. Barney, apparently, what I have here is a report from Wagner. I'm at Ms. Wagner. Ms. Wagner, if you're there, thank you. Record should reflect. We also have Ms. Wagner from probation and parole. What I have is a report indicating that Ms. Wagner wasn't able to get in touch with you, Ms. Barney, to complete the pre-sentence report. Ms. Wagner, can you speak to that, please?
Yes, Your Honor. She finally reached out, according to that case report. She reached out, I think was the last day on December 20th, but my phone tag was very best with her. She would call after hours or whatnot, but she has stayed in contact with me. She just reached out yesterday. I told her there was no way I was going to be able to get a PSI done. I'm just asking if she cooperates this time around with the PSI, if she can be sentenced your next motion day in February.
All right, thank you. Mr. Ziegler, do you have any objection to that?
No, Your Honor.
Okay. Mr. Seeger, anything you wanted to say for the record?
Your Honor, I'm not entirely sure what the disconnect was, but I can say that Ms. Barney has been in very good contact with me. And when I recognized that it was a problem, I had reached out to her, and then she subsequently reached out to probation. To be that as it may, Your Honor, I think that she would be cooperative, and she now better understands what the requirements may be. So they have their numbers. I assume that they'll be able to contact each other now. She has been doing a good job, at least as far as I can tell, in terms of maintaining her sobriety. She has struggled at times, but she wasn't sober living for an extended period of time. She's been working. So hopefully she's on the right track for another year.
All right, Ms. Wagner, do you want her to come over to the office when she leaves the courtroom today?
Yes, Your Honor, please. Thank you.
Okay.
Thank
So,
you.
Thank you. Ms. Barney, it's very important that you participate in this process. We're giving you another chance to do that. If you fail to do that, then the court's going to issue a bench warrant and we'll have you arrested and just held in jail until we can complete it, okay?
I understand. I just thought I had 2 weeks to do it. I didn't realize it was immediate after.
That's why I'm giving you a chance right now. But after today, I'm not going to accept any other. Okay.
I understand.
All right, so just make sure you see Ms. Wagner right after you leave the courtroom today, and then we'll set this for another hearing date. It's important that you continue to stay in touch with Mr. Seeger ahead of that next hearing. Okay.
Yeah, I'm not sure if the Wexford County Jail is available. And we're a little.
Okay.
I just got in touch with the probation officer.
Don't see them connected yet.
And Your Honor, I'm not sure if the sheriff could, because we're gonna presumably somewhat be ahead of time, Your Honor. I don't know if it's possible, only because I have a little bit of a scheduling conflict with the district court. If they need to terms for girls, which is a simple plea, when they log in.
Okay.
And then the only other sentencing I would have would be at 11:15, which I could take care of too.
Just Mr. Smith, is that?
Yes,
He's lodged as well, Your Honor. Or-
we have him up here.
Oh, if he's here, then.
Yes.
You want to do that?
Sure, Your Honor.
Okay, yeah, that'd be great.
And if Mr. Antoine is here too, Your Honor, I could take care of that as well.
You need a chance to talk to Mr. Smith.
No, Your Honor, I went to the Wexford last week. Is Mr. Antoine here too? He's at 11:15. Is he here?
Yes, he is.
Yeah.
Should I do that next?
Yes.
We're on the record now in People versus Gregory Smith, case number 234849. The record should reflect Mr. Smith is present here in the courtroom. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Thomas Seeger appearing on behalf of Mr. Smith.
Date time set for a sentencing hearing in this matter. Mr. Smith, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yeah.
Oh. And Mr. Seeger, are there any additional
Additions.
deletions, or corrections?
No objections to scoring.
Thank you. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any changes to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I think the PSI does a good job laying out the factual circumstances of this case. The defendant has a long history of criminal activity. In this case, it involved cashing multiple checks across 3 counties for which he was able to do so. I don't see any redeeming qualities or features or mitigating factors in this case that would persuade the court to sentence on the lower end of the guidelines. I think prison is appropriate given his record and given his conduct. So for those reasons, Your Honor, I would ask the court to fashion sentence either in the mid or higher end of the guidelines that would send Mr. Smith back to prison so he can't continue to engage in this type of behavior.
Thank you, Mr. Seeger.
Your Honor, and Mr. Smith recognizes what he did was wrong. I think that when you're homeless and you're struggling financially, but be that as it may, Your Honor, I don't think that he has prior criminal history. Guideline for a range of 12 to 24 months, but the plea agreement also requires that he pay restitution. In as much as there is a decent amount of restitution available required to be paid at first. Or sends him to prison for an extended period of time. Or makes it more difficult to pay towards his restitution. In fairness, may not be paid immediately. To the extent that he's incarcerated, clearly he's not going to be able to pay it. So for those reasons, Your Honor, speaking with Mr. Smith, he indicated that he recognizes what he did was wrongful. He would like to have an opportunity to atone for some of his mistakes. So if the court feels that a prison sentence is warranted, I would just ask the court to put it at the lower end of the spectrum to allow him to work on paying his restitution figure for which he had indicated he would make a good pay back.
Thank you. Smith, anything that you wanted to say?
Yeah, I know I made poor judgment decisions, but I was misled into believe what I was doing was legal. You know, I had been just got out of prison, and you know, things had changed around me to where were different on the street for me from when I was in prison, because I had done 10 years, you know, so it sounded feasible to me that what this guy was talking about, that, you know, cashing checks for other people because I didn't have a card, by doing so, that I wasn't doing anything illegal. So I mean, I asked guys, this, you know, am I doing anything illegal here? And he goes, no, it's legal to do this, you know, and I believed him, you know, under full fashion of it. If I thought I was doing something illegal, I wouldn't have done it, sir. You know, I mean, I honestly was influenced and misguided in these situations. And I went ahead with it, and then, you know, then next thing you know, my sister's saying, detective or state officer is looking for me, and I'm going, oh, no, and this can't be good. And then he started talking to my sister, and then we went through with it, and then, you know, come to find out, you know, what I did was illegal.
Okay. All right, well, I read through the report, so I'm familiar with what happened in this case. And then there's a lot of information in that report about your background and your history and so forth, which, as you know, is not good. Got many felonies on your history. You got 8 felonies and 13 misdemeanors, so you have a significant record. It's not a recent thing for you. Just looking at your past offenses, your first offense was all the way back in 1982, shoplifting, and also a charge of robbery back then. You've had a number over the years since then, over the last 30 years, you know, pretty consistent history of theft crimes, assault and type crimes. The only significant breaks in between convictions for you have been because you've been incarcerated. So, you know, maybe you didn't know what you were doing was wrong. I think given your history and your record, by now you should have a pretty good idea when something's off and when something's not. This isn't your first time around. So I think you should have known, or you did know, that what you were doing in this case was probably not above board. Just based on your past history alone, I can't accept that you were just this innocent person who had no idea what you were doing was wrong until the police started asking you. By this time, I think you've got a pretty good idea when something's above board and when it's not. At the very least, you should know not to just trust somebody and say, if they tell you it's okay, well, I'm just going to do it because this guy says it's okay. Again, with your history and your record, you've been around the block enough times to know that that's not a basis if you want to stay out of jail or prison, to not just go along with something. Based on your record, based on what happened in this case, I agree with Mr. Ziegler, the prosecutor. There really aren't any mitigating factors here. You're clearly somebody who's a lifelong criminal. You're clearly somebody who will continue to offend, no matter how many jail or prison sentences you get, which is 11 jail sentences, 8 prior prison sentences. So none of that has had any impact on your willingness to continue to engage in criminal activity. So I agree. At this point, the only thing we can do is get you out of circulation so you can't victimize anyone for as long as possible. The guidelines here call for a maximum sentence of up to 24 months, and I think that's appropriate given what happened in this case and given your past history. So the court is going to sentence you to 24 months in the Michigan Department of Corrections, to 14 years. You do have credit for 143 days served. The court is going to order restitution in the amount of $5,720. That's payable to the Kalkaska County Clerk to be dispersed to, I believe, Huntington Bank. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and a state cost of $68. You do have the ability to appeal the sentence. Terry, if we can grab those appellate rights. Mr. Smith, these papers are going to explain to you what your appellate rates are, as well as how to request the court appointment in order to help you with.
For the record, returning a copy of his appellate rights to the court and just detail this on.
Remanded to the custody of the state.
Thank you, sir. Better.
a little out of order, but I guess we're still way ahead of schedule. So it's- call Mr. Antoine.
If we have Mr. Antoine, we can bring him forward. Okay. Time to speak with.
All right, spoke to him last week.
Okay, the record should reflect Mr. Anton here in the courtroom today. Yes, if I could have counsel with your appearance, John.
Ryan Ziegler, on behalf of the people, Your Honor.
Thomas Siegler, with now the other Mr. Antoine.
This is the date and time set for sentencing in this matter. Mr. Antoine, you had a chance to go through this pre-sentence report and speak with Mr. Seeger about that. Yes. Seeger, are there any additions to Declare any additions to the future, correct? You have any challenges this morning?
No, Your Honor.
Anything on behalf of the people for elocution?
Yes, Your Honor. Your Honor, this is a case where Mr. Antoine unknowingly sold some drugs to an undercover officer. So it was not a confidential informant, it was an officer himself. It was a very straightforward case where the officer was there. He witnessed all the transactions. He was a party to all the transactions. But for the fact that Mr. Antoine has no PRVs, no OBs on this case, I think he would probably be looking at a cell where the court would send him to prison. So I think he's lucky in that regard. But given all that, Your Honor, this is for offense. The guidelines range of 0 to 18 is an intermediate sanction cell. So I would just ask that the court sentence him to a county year, impress upon him the seriousness of his behavior. Obviously, the selling and buying of drugs in this community has had a significant effect. So I think that the county year, even though this is his first offense, would be an appropriate sanction, Your Honor. So I would ask that the court do that, and he should consider himself lucky that this wasn't a prison recommendation.
Thank you, Mr. Seeger.
Your Honor, on Mr. Antoine's behalf, clearly selling drugs is not a positive thing. I do understand why he was doing it. He had explained to me, and it's reflected in the report, that he was trying to prop up his own habit, which unfortunately is a subset of certain people who become addicted to substances. But to his credit, I don't look at it as a question of whether or not something's lucky. I look at it in the sense of the court takes into consideration somebody's prior criminal history, and the guidelines take into consideration their prior criminal history. In this particular case, he does not have a long, extensive criminal history, and that's why the guidelines are, I want to call them favorable, Your Honor, but they are, for lack of a better phrasing, Your Honor, I'll say that they're favorable. Mr. Antoine recognizes what he did was wrong. Mr. Antoine recognizes that what he's done has caused him pain and that he's going to be incarcerated for a period of time. I would likewise ask the court to consider giving him a county time sanction of some sort where he can reflect upon what he's done. I don't think that probation would be appropriate. There's currently a pending case, Your Honor. I'm not sure if you're the judge or not, or if it's Judge Hunter. I did talk to Mr. Brown. And it appears as though that case was going to resolve itself one way or another. So if you're the judge in that case, I just case, if it's resolved. But be that as it may, Your Honor, as it stands today, for his individualized sentencing, he does not have a long extensive criminal history. He does have some pluses to him, in as much as he does not appear to have a long work history. He is a relative. 5472. I would like to believe that he has the time to rehabilitate himself. He expressed remorse for what he was doing. And I think that the time that he's been incarcerated has allowed him to somewhat regain some of his clarity in terms of where he wants to go with his life. He's expressed his been a negative thing for him, but sometimes when he's sitting in jail for a period of time, you know, so be that as it may, Your Honor, I just ask for the court to give him a county time sanctioned with no probation, and if at a later date, the court handles it different. He considers its position depending on how he's done one way or another.
Okay, thank you. Mr. Antoine, anything you wanted to say? Read through the report, so I'm familiar with what happened here. You're a young man, you're kind of jumping into the deep end here between this case and what's going on over at CO, but both cases, similar conduct, involved in selling substances. Unfortunately, for you to confidential informants or undercover narcotics officers. And those carry with it significant penalties. I understand people selling to support their habit. That's not an uncommon thing. But it does make it more serious than just using or possessing. So that's something you have to think about going forward, because your guidelines are only going to get worse from here. And eventually you're going to wind up with no option but a prison sentence. In this case, I do think that the sentence in the middle of the guidelines is appropriate. There are some mitigating factors for young man who don't have a significant factor at this point. I think that, you can turn this around, you can become productive, you can avoid spending time sitting in jail and more time doing the things that you want to do. So I think a sentence in the middle of the guidelines reflects those mitigating factors, but also the seriousness of what you were doing. Again, the guidelines are 0 to 18, so I think a 9-month sentence, which again is right in the middle, is appropriate to address both of those competing interests. So the court is going to sentence you to 9 months in the Kalkaska County Jail. You do have credit for 78 days served. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350. Testing fee is $60, and state cost of $68. You do have the ability to appeal papers that explain to you what your appellate rights are, as well as request a court appointed lawyer to help you with any appeal. For the record, Mr. Seeger, I believe that Seagull case is in front of Judge Hunter, so I'm not sure what the status of that is.
Thank you. And Your Honor, for the record, returning a copy of his appellate rights and then returning a copy of his.
You are remanded to the custody.
Thank you. Have a great day, Your Honor.
Thank you. I don't see Mr. Burrows yet.
Your Honor, I think they didn't bring in.
Presumably, yes.
All right, our next hearing is set for 10 o'clock. So we'll
circuit.
Okay, Mr. Travis, I'm not sure where we're at yet, so if we could just stay on the line. All right, at Wexford County Jail, sir, can you tell me your name, please?
Jeremy Schimmel.
Mr. Schimmel. Mr. Travis, are you able to hear me okay?
I am, Your Honor.
Okay, so we'll go on the record then in People versus Jeremy Schimmel, case number 234874. The record should reflect Mr. Schimmel's present today by video from Wexford County Jail. Mr. Travis is also present by Zoom by prior approval of the court. Mr. Ziegler is present here in the courtroom today. This is set for a status conference. Mr. Travis, can you tell me where we're at with this file, please?
Yes, Your Honor. Mr. Schimmel waived the prelim based on a plea offer, and he would like to accept that plea offer after some consideration of it. My understanding of the offer is if he pled to an attempt, resisting, and obstructing, the prosecution would dismiss the existing charge of resisting and obstructing as a felony, and also a misdemeanor violation of domestic violence charge.
All right, Mr. Ziegler.
Fair statement of the offer, Your Honor.
Mr. Schimmel, were you able to hear that?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Have you had adequate opportunity to speak with your attorney, Mr. Travis, about this?
Yes, I have.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I do.
Thank you. You can put your hand. Mr. Schimmel, are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to resisting or obstructing a police officer as an attempt, that the maximum penalty you could face would be up to 1 year in jail?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want to. You understand all of those rights.
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty. You won't have.
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
The information I have indicates that this incident happened on November 3rd of 2023. Is that the correct date?
Yes, it is.
On that date, did you come into contact with a Kalkaska County Sheriff's deputy?
Yes, sir.
Where did that take place at?
My home.
Can you tell me that address?
10158 Puffer Road.
That in Fife Lake?
Yes, sir.
Okay. Was that deputy wearing his uniform at the time?
Yes, he was.
Were you aware that he was there performing his duties as a police officer?
Yes.
And what did you do to attempt to resist or obstruct that officer at that time?
I closed the door in his face and he came in and physically hit me to the floor and arrested me.
Was he there responding to a call for some reason?
Yes.
Okay. All right, Mr. Ziegler.
I'm satisfied, Your Honor.
Mr. Travis, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis, are you?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Your Honor.
Mr. Travis, are you?
Yes, Your Honor.
Thank you. Mr. Schimmel, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. And somebody from the probation department will be in touch with you. Mr. Chair, if we could just have just a misdemeanor PSI, just so I have a better idea of the facts here.
Absolutely.
Mr. Travis, anything further that we need to address on this file today?
Yes, Your Honor, if we could address bond.
Okay, what's bond currently set at, do you know?
I believe it's, I think it's currently 5,000, 10%.
Okay, what are you asking the court to change it to?
If the court would consider granting it as a PR bond, Mr. Schimmel has not been able to post. It is not extensively high. I think some of that, the prosecutor has previously not been thrilled with the conduct, as this did get physical. There weren't any injuries or anything of that nature. But Mr. Schimmel has been in jail for about 60 days now and has been unable to post. So we would ask the court to consider granting a PR bond.
Mr. Ziegler?
Your Honor, we would oppose a PR bond. This was a situation where officers responded to a domestic. Well, he's not pled guilty to the domestic violence. The victim on the domestic violence did have injuries. At that point, police went to detain Mr. Schimmel. He physically fought with cops. He kicked Deputy Xavier. The struggle was so significant that the officers had to tase him. For those reasons, Your Honor, I think the bond as currently set is appropriate.
All right, again, the bond is set at $5,000, 10%. That's a reasonable bond, given that Mr. Schimmel's entered the plea today. It's no longer a matter of pretrial release. So the court finds that the bond should remain as set pending sentencing. And of course, Mr. Schimmel will continue to accrue credit for the time that he's lodged pending that sentencing hearing. Beyond that, Mr. Travis, anything further today?
Nothing further, Your Honor. Thank you.
All right, Mr. Schimmel, thank you. That's all for today. And the court's going to put Waxford on hold for right now.
Okay, thank you, sir.
Is Mr. McGuire, Mr. Travis, you know if Mr. McGuire is live?
No, I don't believe so.
Okay, Mr. McGuire, if you come forward, please. Mr. McGuire is present here in the courtroom, Mr. Travis, so we're going to call his case right now.
Thank you, Your Honor.
This is People versus Jonathan McGuire, case number 234847. The record should reflect Mr. McGuire is present here in the courtroom today. Mr. Travis is present by Zoom. Mr. Ziegler is here on behalf of the people in person. This is set for a plea hearing today. Mr. Travis, how did we want to proceed in this file?
Your Honor, the court had previously granted an adjournment and set it for a plea hearing because Mr. McGuire was pursuing getting into sobriety court. It is my understanding, and Mr. Ziegler may have updated information, but I believe sobriety court is still looking at him and hasn't accepted or denied him. And if that's the case, we would ask for one more adjournment, Your Honor.
Mr. Ziegler.
Ms. Gomez, yesterday, she didn't have her notes in front of her. She could not recall when the last time she had contact either with Mr. McGuire or his attorney was. She said she would update me this morning before court. As of the time we took the break, Your Honor, at about 9:45, I still have not had any contact with Ms. Gomez. To the best of my knowledge, the team has not made a decision regarding his eligibility for sobriety court. The people would not oppose one more adjournment in this matter.
Okay, Mr. McGuire, do you have any objection to that adjourning this out so that we can get a final decision?
No, Your Honor.
Okay. All right, so the court will set this for another hearing in about 30 days. And Mr. Ziegler, I mean, do you anticipate we'll have a decision one way or the other at that point?
I do, Your Honor, and I would just ask that if, I don't know what the status of the contact has been between Mr. McGuire and Ms. Gomez, but I would just ask that the defense make efforts to get hold of her and arrange whatever needs to be arranged for the next hearing.
Okay, so Mr. McGuire, we're gonna put that on you and your
Yes,
lawyer
sir.
to make sure that you make contact with Mr.
Yes, sir. I did try contacting her yesterday, but the phone kept going straight to voicemail. It's an automated voicemail. So I called my lawyer, asked for the number to make sure we got in contact and I had the right number. So I do not know what's going on. I left a message
Okay,
as well. So
all right.
just kind of waiting myself too.
Okay, so if you can just continue to follow up with that.
Yes, sir.
And we'll go forward in about 30 days.
Yes, sir.
Thank you. Thank you. Okay, there at Waxford, we just need you to unmute on your end, please. Okay, sir, can you tell me your name?
Micah Burrows.
Record is People versus Burrows, case number 234833. The record should reflect Mr. Burrows is present today by video from Waxford County Jail. If I could have counsel put your finger on.
Ryan Ziegler, yes, legally honest.
Thomas Seeger, bring with on behalf of Mr. Burrows.
Right, Mr. Burrows was arrested in December. Based on a failure to appear for a hearing back in October, in which the court revoked his bond and issued a bench warrant. So he's been lodged in Wexford County. It's, let's see, December 26th. The court then set this for a status conference today. Mr. Seeger, how did we want to proceed today?
Your Honor, it's my understanding that Mr. Burrows is going to plead to an added count 3 of possession of analogs. In exchange, count 1 and count 2 would be dismissed.
Mr. Ziegler,
Fair statement, Your Honor.
is this the same charge as
Just
the
a little
first
back,
case
Your Honor.
this morning?
Yes.
Okay, do you still have that back? All right. And are we gonna take the factual basis to the fentanyl as the substance?
That's fine, Your Honor.
Okay. Mr. Burrows, have you had a chance to speak with Mr. Seeger about this plea agreement?
Yes, I have.
And were you able to hear what he said as to what the terms of that agreement are?
I believe so.
So what you would be entering a plea to today under that agreement is possession of analogs, which is a 2-year felony. In exchange for that, the charge of possession of fentanyl would be dismissed, as well as the trespass.
Yes, sir. Yep.
Okay. Is that how you wanted to go forward today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Burrows, are you currently on any kind of probation or parole?
I'm on probation in Charlevoix, Charlevoix County, misdemeanor probation.
All right. You understand that by pleading guilty to this charge today, that could result in a violation of your probation there?
Yes, sir.
And that you could face penalties. I don't know what those would be, but you could face some penalties in addition to what's going to happen in this case for violating your probation.
Yes, sir.
And as I stated, you understand that the maximum possible penalty you could face in this case would be up to 2 years.
Yes, sir.
With all of those things in mind, what is your plea to the charge of possession of analogs today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
Can you tell me what's going to happen to those rights by you pleading guilty today?
But it's gonna be waived, right?
That's correct. You're going to be giving up all of those rights, including the right to have a trial. Has anybody forcing you to do that?
No, sir.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
And is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
The information I have indicates this happened on June 26th of 2023. Is that the correct date?
I believe so. Yes, sir.
On that day, were you present here in Kalkaska County?
Yeah.
While you were present here in Kalkaska County, did you have possession of some fentanyl?
I did, sir.
Did you know that that's what that substance was?
I did.
Did you have any legal right to have that at that time?
I did not.
Thank you. Mr. Ziegler, are the people satisfied with the factual basis?
I'm satisfied, Your Honor.
Mr. Seeger.
Likewise, Your Honor.
Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Yes, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you. Mr. Burrows, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Someone from the probation department will be in touch with you to do a pre-sentence report. Mr. Seeger, anything else we need to address for the record?
Your Honor, the only request is whether or not the court will consider reinstating bond. My understanding of why Mr. Burrows missed the hearing was primarily related to him being homeless. He's since rectified his living situation. It's my understanding that previously he did not have a standard living situation. He didn't have a contact number either. So it was difficult to try and contact him. At one point in time, he did attempt to contact the clerk to verify when the next court date, and it must not have been set at that time. But be that as it may, or he does recognize that he would have to follow up with the clerk and or his attorney to determine when the next date would be. But he did not intentionally miss court.
Mr. Ziegler.
Your Honor, given the fact that he's prior failed to appear on 2 occasions, given the fact that we're past the plea phase, so the court now has a plea, there's no more need for pretrial release. I would just ask the court to hold him pending the sentencing date.
All right. Given that, again, as Mr. Ziegler indicated, this is no longer a matter of pretrial release. Mr. Burrows has entered a guilty plea. Given the past failures to appear, the court finds that it would be appropriate that Mr. Burrows remain lodged until the time of sentencing. So, Mr. Burrows, if you're going to remain there at Wexford, you'll be transported here to Kalkaska for purposes of that sentencing hearing. And that's all for today, and the court's going to disconnect from Wexford at this time.
And then I have Mr. Evans.
People versus Anson Evans, case number 234811. The record should reflect Mr. Evans is present here in the courtroom today. If I could have counsel put your appearances on.
Thomas to go train with Mr. Evans.
How did we want to go forward today, Mr. Senior?
Your Honor, I would ask the court to consider an adjournment. I did speak to the prosecuting attorney about this matter. At this time, Mr. Evans has retained alternate counsel. Mr. I'm not sure what Mr. Thompson is doing. I did contact his office. However, the attorney of record who will be taking my place, I don't know about. Thompson, what his position is going to be. Horowitz is going to be stepping into the file. As I had notified the court at the last motion hearing, Mr. Evans had wished to seek an interlocutory appeal for which the transcripts have just been received. So my understanding, just fine through speaking to Mr. Horowitz, is that he will file leave for application to leave. For those who do that, I can't specifically say, but he does have the transcripts, so it'll make it easier. File that paperwork.
Okay, Mr. Horowitz.
That's all accurate, Your Honor. The transcripts are received shortly before Christmas, I believe. We'll be filing a delayed application for leave for interlocutory appeal shortly, probably within the next couple of weeks. And as I had been working on that, Mr. Evans has asked that I step in and take over the case in the trial court as well.
Okay, so if you can file an appearance along with your appearance here in court today on the record. Mr. Ziegler, people take any position?
Your Honor, given that Mr. Horowitz is just subbing in, given the the procedural posture of the case, the people don't have any objection to the adjournment.
Okay, the court's going to set this for hearing in about 60 days for a status conference. And at that point, we'll see where things are at in terms of the appellate process, Mr. Horowitz, and we'll go from there. Mr. Evans, any questions about how we're going to go forward? No, sir. Mr. Seeger, anything further?
Your Honor, I do have an executed copy of a substitution of counsel. It's going to file with the clerk just to be clean.
Perfect, thank you.
Thank you, Judge.
Okay, thank you. Hearing is set for 30 with Mr. Guerrero last week. Last summer.
Yeah.
Anyway.
Okay.
I don't see them connected yet, so let's just take a short recess and we'll be back on the record in about 5 minutes. Ms. Vandenberg, are you able to hear me okay?
Yes, Your Honor. Good morning.
Good morning. I'm just waiting for Antrim County to connect with your client. I don't see them yet.
Okay, thank you.
So if you don't mind just waiting, and I'll put you back in the waiting room, and as soon as I have them connected, we'll get going.
Thank you.
Oh, we're gonna give them a call.
Yeah, that'd be great. And our probation officer is going to call Antrim County to see if they can spur things on.
Okay, thank you, Your Honor.
Okay, thank you. And sir, what's your name?
Early.
Mr. Carlin?
He is 10:45.
Okay. Ms. Vandenberg, it sounds like it's going to be a minute or two until we can get Mr. Aguero on camera. So if you can just hold on for maybe another 5 or 10 minutes.
Yes, sir. Thank you.
Okay, thank you. All right, I'm going to take a short recess. Okay. Mr. Guerrero, are you able to hear me okay?
Yes, sir.
Okay. All right, we're on the record in People versus Elijah Guerrero. This is case number 234860. The record should reflect Mr. Guerrero's present by video from Antrim County Jail. We have Ms. Vandenberg on his behalf, also by Zoom. Mr. Ziegler is here on behalf of people in the courtroom. This is set for a status conference today. Ms. Vandenberg, can you tell me where things are at with this file at this time?
Yes, thank you, Your Honor. Your Honor, Mr. Ziegler and I have had an opportunity to speak regarding this case. As Mr. Ziegler, I believe, that stated to the court previously, this is a very complicated case, a lot of moving parts, but we have come to an agreement with regard to the what Mr. Guerrero will plead guilty to, it, I should say no contest to. So in that regard, I would defer to Mr. Ziegler.
Your Honor, the plea offer in this case is that Mr. Guerrero would plead to one count of involuntary manslaughter. People would not object to that plea being taken as a no contest plea. In exchange, all of the counts and enhancements would be dismissed.
All right, Ms. Vandenberg, is that a correct statement from your standpoint?
Your Honor, that is a correct statement. We also spoke with regard to sentencing, and I haven't had an opportunity, other than the conversation that we've had, Mr. Ziegler and I, about a week or so ago. So I have scored the guidelines, and I've scored and rescored, and I come up with each time 3 to 5. And so Mr. Ziegler and I spoke with regard to sentencing at the low end of the guideline, and of course that would require the court's permission. So
oh, I'm sorry, go ahead, Ms. Vandenberg.
Sorry, Your Honor. You may go ahead.
Mr. Ziegler.
Your Honor, my understanding was that the defense was going to seek a Cobb's recommendation from the court as to whether or not the court would be inclined to sentence on the lower end of the guidelines. I don't believe we had a sentencing agreement for the court to sentence on the lower end.
Okay, so Ms. Vandenberg, it's my practice not to engage in Cobb's negotiations. If you're able to come to an agreement with Mr. Ziegler, I don't have a problem taking the plea as a killabrew, where if I decide not to go along with the agreement, I would allow Mr. Aguero to withdraw the plea. I don't know. It sounds like Mr. Ziegler may or may not agree to a killabrew type of thing. And then my other concern is with regard to the no contest, I don't have a police report today to be able to take that plea. So I wonder if we set this for a separate plea hearing, or if it's going to be a no contest, if the parties can submit a police report to me ahead of time. And then if we can have some kind of definite statement whether or not a sentence is going to be part of the agreement. Mr. Ziegler, do you have any objection to that?
Your Honor, I think that makes sense for both of the reasons the court stated, so I have no objection to a brief adjournment setting up for a plea hearing.
Ms. Vandenberg, what's your thought on that?
Your Honor, I have no objection either, but again, in my conversation with Mr. Ziegler, my understanding was that he did not oppose a plea agreement. And so, again, the court doesn't engage in Cobb's, and I understand that. So I think that it's prudent for the court to set this for an agreement or some hearing with regard to the agreement, or whether or not there will be an agreement. Having said that, Your Honor, and with regard to the police report is about 98 pages long. I mean, it's just voluminous. I wonder, I'm not sure that Mr. Ziegler, I would imagine Mr. Ziegler has an affidavit in his file. And if the court can review the affidavit, that might save some time.
I agree. We can do it that way, or if counsel wants to, in the interim, prior to the hearing, if the two want to agree to the portions of that report that are relevant to establishing the factual basis, and just submit those particular portions of the report to the court, I think that would also be a good way, rather than reading through 100 pages of police reports. Mr. Ziegler, do you have any objection to doing that?
I don't have an objection to either of those methods, Your Honor.
Okay. All right, so I'm gonna set this for a plea hearing at a separate date. I'm gonna ask counsel to confer and attempt to reach an agreement in terms of whether or not a sentence is gonna be part of the plea agreement, number one. Number two, I'm gonna ask counsel to confer and submit to the court either portions of the police report that are relevant to establishing a factual basis, an affidavit, or a combination of both to the court prior to that hearing, so that that I have that and can be prepared to take the plea.
Thank you, Your
And,
Honor.
And then we'll go from there. Ms. Vandenberg, anything else from your side that you think we need to address?
Your Honor, I have nothing further. I just would need to speak with Mr. Ziegler, and hopefully Mr. Ziegler has some time today, or just after, perhaps we can be put to a breakout room and I can confer with Mr. Ziegler so that we can get a date sooner, sooner than later for the plea hearing.
I'll have some time this afternoon. If you want to give me a call this afternoon after court, that would be great.
Okay, Mr. Ziegler, what time are you available this afternoon?
I've got a couple things at 1:30. Anytime after 2:30 should be fine.
Okay, I'll call you at 2:30. Thank you.
Thank you.
Excuse me.
Yes, go ahead, Mr. Aguero.
Would I be able to be in a break room with Ms. Vandenberg?
Oh, you separately, are you speaking?
Yes, separate. Just to go over things.
Ms. Vandenberg, do you want me to put the two of you into a breakout room?
Yes, thank you, Your Honor.
Okay. Okay, thank you. That's all for this hearing today. I'll open that breakout room right now. And then we'll move on with our docket here in the courtroom.
Thank you. Okay, Elijah, I think we're.
Hold on, there we go.
Hold on just a second. Let me join.
Still on the record, so there we go. Okay, People versus Brian Carley, case number 234873. If I can have Mr. Carley up at the podium, please, and counsel, if you can both put your appearances on.
Speaking on behalf of Mr. Carley.
Set for a status conference today from the defense side. Mr. Hano, can you tell me where things are at with this case?
Thank you, Your Honor. I've spoken with the prosecutor in this case. He currently has two cases going on at the same time. One is from Grand Rapids, which is another controlled substance case, cocaine in that instance. That's newer than this. This is an older case. We have spoken with the drug court in Berry County, which is where he lives. I think he's a good candidate. We've discussed entering a plea today, conditioned upon his placement in that, whether this county would accept a transfer into that program. I know the CAO new guidelines for transferring into drug court are a little different, so they said it's been a little bit different with each county whether there would be a transfer. I believe the case has to wrap up here first, and then they send the entire thing down there. So we'd like to enter a plea conditioned upon the transfer to that to I believe it was as charged with no subs.
Our offer would be to count one with no habitual offender notice, and that plea would be contingent on his acceptance and transfer into drug court. We're contemplating Berry County, I believe, but whichever drug court you can get into would be acceptable.
Okay, Mr. Hano, do you have any sense of where the process is there?
I've spoken with the court. They said he'd be a good candidate. They said to see how things go today and get an assessment down with him. It's scheduled. He hasn't had his drug assessment yet, though.
Okay. Are you representing him in that file as well?
Yes, I am.
All right. Okay, so I don't have any objection to taking it as a conditional plea today, subject to that, as counsel's indicated. Mr. Carley, have you had a chance to speak with your counsel about this plea that you're going to enter in this case today?
Yes, I have, Your Honor.
Okay. And you understand that plea agreement would involve you pleading guilty to one count of possession of methamphetamine, and in exchange for that, The other charges and enhancements would be dropped, and then plea would be contingent on your acceptance into a drug court program in that other jurisdiction.
Yes, Your Honor.
Okay. Are you currently on any kind of probation or parole?
No, Your Honor, I'm not.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. So Mr. Carley, you understand that the maximum possible penalty that you could face by pleading guilty to this charge is up to 10 years and or a $15,000 fine.
Yes, Your Honor.
And with that penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand that you have all those rights?
Yes, Your Honor.
Do you understand that you're giving up and waiving all of those rights, including the right to have a trial by pleading guilty today?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, it is.
Are you pleading guilty because you are in fact guilty of this charge?
Yes, Your Honor.
The date that I have here is that this occurred on was January 11th of 2022. So it's nearly 2 years ago now. Is that the correct day?
Yes, sir.
Okay. On that day, were you present here in Kalkaska County?
Yes, sir.
And while you were here in Kalkaska County at that time, did you have possession of some methamphetamine?
Yes, sir.
But that's what that substance was.
Yes, Your Honor.
Did you have any legal right to have it at that time?
No, Your Honor.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Hinkle?
I am, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Hinkle?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Hinkle?
Yes, Your Honor.
Mr. Carley, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea, again, subject to the conditions that we put on the record here today. I'm going to set this matter for a sentencing hearing in about 60 days. Normally, I would do it 30 days out, but I want to make sure that we're not wasting everybody's time. Give this process a chance to
Thank you, Your Honor.
So we'll set it for sentencing in 60 days. And if you can just meet with Mr. Bear up here before you guys leave court, he's going to want to set up a pre-sentence interview process for you. Anything further on this file, Mr. Hano?
Nothing further, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay, thank you. That's all for today.
Thank you, Your Honor.
Mr. Corway, were you ready with your file?
Sure. I don't know if he's on. It's Dalion Fields. He should be on from another correctional facility.
See that? Did we get a writ for that, Mr. Ziegler?
I do have a writ signed by Your Honor for today's date, 10/45. You should be in the Ingham County Jail, Your Honor.
Have you had any contact with them recently, Mr. Horowitz?
I have, Your Honor. I don't need any further contact. It'll be a plea if we get him on.
Okay.
Assuming Your Honor takes it.
All right, let's just pass on that file right now. Browse, are you ready with your file?
I am, Your Honor.
Okay. People versus May, case number 234826.
Ryan Ziegler, yeah, keep it on.
Scott Isles, on behalf of Mr. May, who's standing to my left, Your Honor.
The date and time set for a sentencing hearing in this case. I think we've been kind of adjourning this out.
Yes, Your Honor, for the record, I got hired really at the 11 3/4 hour the day before sentencing. We adjourned this to see if we could get him into sobriety court. Not only have we been successful, he's already started. However, in order to qualify for sobriety court, he can't have a felony violent crime, and he's got a felonious assault. So what we'd like to do today is withdraw his plea and then replea him to a misdemeanor assault and a felony drunk driving third.
Okay, so as it stands right now, he's pled to the felonious assault and OWI second, correct?
Yes.
Okay, Mr. Ziegler.
That's correct, Your Honor, and that's a fair statement of the withdrawal of the new offer.
Okay. Mr. May, this is a bit of an unusual circumstance, but have you had a chance to discuss all of this with Mr. Isles?
I absolutely have, sir, and have been thoroughly explained.
Okay, so you understand that we're gonna essentially be flip-flopping these two between misdemeanors and felonies?
Yes, sir.
Okay, do you need any more time to talk to him about that before we go forward?
No, sir.
Okay. So, I do want to go through a few things with you for the record. I don't think we need to take, another factual basis. I think we can rely on Mr. May's prior testimony, but I do want to make sure that he fully understands the consequences and the changes in this case. So, Mr. May, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God?
I do, sir.
Okay. So, Mr. May, and I'm doing this because in essence, the penalties for operating while intoxicated as a third offense could be greater than those for felonious assault. So that's primarily why I want to do that. Because the maximum possible penalty for a felonious assault charge is up to 4 years. And you understand that for an operating while intoxicated as a third offense, if you were to fail to successfully complete sobriety court or probation, if it's ordered in that case, that the maximum penalty you could face for that charge would be up to 5 years and or a $5,000 fine.
I do understand that, correct, sir.
And then what was the misdemeanor charge, Mr. Isles?
Assault and battery?
Is that it? Okay, just a simple assault and battery. Okay. And then you understand that the maximum penalty you could face for assault and battery would be up to 93 days.
I do understand that, sir.
So with all of those penalties in mind, what is your plea to each of those charges today?
I plead guilty to both of those charges, sir.
Okay. Has anybody threatened you with anything to get you to do that?
No, sir.
Has anyone promised you anything other than what we've discussed here in court?
No, sir.
Is it your own free choice to enter those pleas?
It is, sir.
Okay. Mr. Isles, do you have any objection to the court accepting Mr. May's prior testimony at the plea hearing as a factual basis for finding of guilt as to each of these charges?
None, Your Honor.
Mr. Ziegler?
Your Honor, just with the exception that we need to establish an additional prior OWI.
Yeah, Mr. May, I'm going to ask you a couple questions about your previous alcohol-related driving offenses, okay?
Yes, sir.
And so had you previously been convicted of operating while intoxicated in district court here in Kalkaska in 2016? March of 2016?
In Kalkaska?
Oh, I'm sorry, 86 district court, so no.
Yes, sir, that's accurate.
Okay. And then of operating while impaired back in 2004 in 54A district court.
That's accurate as well, sir.
Okay. With that, Mr. Ziegler?
I'm satisfied with the factual basis, Your Honor.
Okay. Okay, so the court will accept Mr. May's Number one, the court will allow Mr. May to withdraw the previous pleas. The court will accept the new pleas as indicated here today. Based on his prior testimony, as well as supplemented testimony, the court finds that there is a factual basis to support a finding that he is guilty of each of those new charges. And the court will accept the guilty plea as to both. With regard to sentencing, how do we want to proceed today? I know he's already participating. That's good. We want to keep that going. I don't know, obviously.
The scoring may change because of the change in the felonies. We probably need to get a new PSI.
Okay.
I would agree, Your Honor.
Okay.
Hate to put that on the probation department.
All right. So the court's going to refer this for preparation of a new PSI with the anticipation that the court would place Mr. May on probation with major additions of that probation. Participation in this.
No, Your Honor.
Mr. Ziegler.
No, Your Honor.
Mr. May, do you have any questions about how we're going to go forward?
No, sir.
Okay. So just make sure that you cooperate with anything that Mr. Barrett may need with regard to a new pre-sentence report, and then of course, make sure that you continue participating with the Friday program.
Yes, sir.
Okay, thank you.
Thank you, Your Honor.
Thank you.
Bye.
And Mr. Horowitz, I'm gonna see if we can get a hold of England and see where Mr. Fields is at. We'll take a short recess. Okay, we're on the record in Dalian Fields, People versus Fields, case number 2348770. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Michael Horowitz on behalf of Mr. Fields.
So we haven't been able to secure Mr. Fields' appearance here today, and obviously a writ was prepared and signed by the court back on December 5th, so I'm not sure where the disconnect is. So if the court's going to attempt to reschedule this, Mr. Ziegler, if you could confirm Mr. Fields is still in Ingham County and prepare another writ, and we'll give it another shot. Mr. Horowitz, anything you want to place on the record today?
No, other than I've got a pretty wide range of availability today. If the court did have room and somebody found him, I'm around and I would be happy to jump in on Zoom if I'm not here today, or not at the court still. Also, the hope is that it will be a HIDA resolution.
Okay.
So I don't know what that means in terms of sentencing. That probably it will be a plea with sentencing set out.
Okay.
I just know that he's somewhat eager to get it taken care of.
Okay, understood. Thank you, Mr. Ziegler.
Your Honor, I have no objection to the court's outline procedures.
Okay. All right, thank you. If we are able to somehow get that to work, we'll let counsel know. Otherwise, the court will send out notice of the new date and time. Next hearing's at 11:30. We'll be in recess until that.
Thank you, Judge.
Okay, we're on the record in, hold on a second. Okay, we're on the record in People versus Ashley Klein, case number 234857. Mr. Travis, are you, have you been appointed to this case?
I have, Your Honor, and I apologize. I missed it earlier because it's listed as pro per when I was talking about the cases I had.
Okay, so we have Mr. Travis here on behalf of Ms. Klein. Mr. Ziegler's here on behalf of the people. This was set for a sentencing hearing at 11:30. It's now 11:35. I don't see Ms. Klein present either in the courtroom, or she hasn't tried to connect by Zoom. Have you had any contacts with her, Mr. Travis?
I haven't. That's been an issue with Ms. Klein. She has reached out to me by phone, but I don't think she's had her own phone number through most of the case. So we have struggled with communication. She's always appeared, and she has reached out to me by phone in the past, but generally she's just appeared to court.
All right, Mr. Ziegler, do people take any position?
Your Honor, I have just given Mr. Travis is saying she's appeared at all prior hearings. She's had no prior criminal history of any kind. I do understand that this is a sentencing. We need to get this done, so I'll leave it to the court's discretion as to how to proceed.
All right, I'm just going to set this for another sentencing hearing and a show cause for her failure to appear today. I don't see anything in the file that indicates she's a flight risk. This is her, appears to be her first criminal offense. The recommendation isn't for any kind of substantial jail time, so there wouldn't appear to be any motivation for Ms. Klein to flee the jurisdiction or otherwise intentionally fail to appear. So I'm going to give her the benefit of the doubt for purposes of today's hearing and simply reset this. Mr. Travis, anything further that we need to place on the record today?
Nothing further. Thank you, Honor.
Mr. Ziegler.
No, Your Honor, thank you.
All right, thank you. That concludes our morning docket. The court will be in recess until 1:45.
Thank you, Honor.
That's